Hello and welcome to Lecture 8. This lecture marks a turning point in our short semester where we dig into the actual process by which cases land on the Supreme Court's docket and where we'll take apart judicial decision making at each stage of the judicial process. So here we start at the beginning with the Supreme Court's agenda setting process. This lecture is the first of a two-part series. In the first, we'll look at legal and procedural requirements, examining the mechanics of how the agenda setting process actually works. Then, in the next lecture, Lecture 9, we'll bring social science to bear as we consider what motivates justices to behave the way they do during this foundational stage. This means that in this lecture, we're going to lay the groundwork for what comes next, and it's quite full of technical jargon, but we'll walk through it slowly and deliberately so that hopefully you grasp the full picture. To begin, we'll consider what the Constitution tells us about the Supreme Court's agenda-setting process. It gives us broad parameters about the types of jurisdiction that we'll encounter, and we'll trace the evolution of how cases land before the Supreme Court over time. Then we'll dissect the legal and normative constraints on the types of cases that come before the Supreme Court, before we finally move on into the technical process by which a case actually lands on the Supreme Court's docket. In short, we want to understand how the Supreme Court sets its agenda and determines its docket by looking at where cases come from and how they get to the court in the first place. Article 3 of the Constitution established the federal judiciary, and Section 2 of Article 3 gives us the parameters for the agenda-setting process by establishing two ways for cases to come before the Supreme Court. It says, in all cases affecting ambassadors, other public ministers and councils, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. So there's one type of jurisdiction. In all other cases, the Supreme Court shall have appellate jurisdiction as to law and fact with such exceptions and under such regulations as the Congress shall make. The Constitution tells us that this second type of jurisdiction, its appellate jurisdiction, is going to come with a contingency factor based on what Congress says. This means that the Supreme Court is not completely free from Congress here. Let's unpack this a bit. First of all, jurisdiction simply means what cases or issues the Supreme Court has the ability or the right to review. If the Supreme Court lacks jurisdiction, it means it doesn't have the right to hear a case. This should sound awfully familiar, right? It's precisely what we talked about in Marbury versus Madison earlier this semester. Okay, so we know that the Constitution gives us two types or flavors of jurisdiction. The first is original jurisdiction. This means that the court functions as the court of first impression, which is to say that it is the court that hears the initial case and therefore acts as a trial court. We know that the Constitution defines this very narrowly, limited to cases affecting ambassadors or cases where there's some sort of conflict between states. So one state is going to sue another state. And Marbury versus Madison said that Congress can't mess around with the scope of original jurisdiction because it's constitutionally defined. Because it's narrowly drawn, right off the bat, you should expect that only a few cases ever fall under the court's original jurisdiction in any given term. The second type of jurisdiction is its appellate jurisdiction. To take a step back, remember that there is an appeals process. Whether the case originates in state or federal courts, it begins at a trial court, then there's an intermediate appellate court, and then it comes to the Supreme Court after someone wins and the other party loses in that lower court. Because the Constitution gives Congress a role in appellate jurisdiction, we have two subcategories of appeals. Mandatory appeals are the subset of cases that the Supreme Court has to hear because Congress says so, and discretionary appeals are those where the Supreme Court gets to choose whether or not to hear a case. We'll talk more about that distinction momentarily. In the United States, if you lose in the trial court, you have a right to appeal your case. You get one appeal. You don't have to use it, but if you do and you lose, you can continue to appeal your case but the subsequent appeals are at the discretion of the appellate court. So you don't have to use the appeal, you can use it, but the appellate court, if you continue to appeal your case after they've heard it once, don't have to continue to hear the case. That process of losing in a trial court and appealing to an intermediary court, where that intermediary court has to hear at least one of your appeals, that's how it functions in the lower federal courts. The Supreme Court, unless Congress tells them that there's a class of cases that they have to hear, has discretion whether or not they're going to take an appeal, even if it's the first time you've appealed it to the Supreme Court. We'll talk much more about the development of the Supreme Court's discretionary docket in a moment, but I wanted you to have a sense of how the appeals process worked from trial court in order to get to the Supreme Court in the first place. So there are multiple hurdles to exercise before you get to the Supreme Court. For much of the nation's history, there was a subset of cases that the Supreme Court had to hear. Actually, until the Judiciary Act of 1891, Congress said that the Supreme Court had to hear every appeal that was appealed to it. But then in 1891, Congress created the United States Courts of Appeals to hear all cases appealed from district courts, while at the same time carving out a small discretionary docket for the Supreme Court. Then, 34 years later, Congress passed the Judiciary Act of 1925, which expanded the court's discretionary jurisdiction and gave the court even more authority to determine its own agenda. This is a pretty critical piece of legislation because it created what are known as writs of certiorari, which means to be heard. This means that if you lose in a lower appellate court, and you appeal your case to the Supreme Court, you would file what's called a writ of certiorari, asking the Supreme Court to hear your case. This initial action in 1925 gave the Supreme Court greater control over the types of cases it heard, while still demanding that the Supreme Court hear a smaller subset of certain cases. The developments of the Judiciary Act of 1925 developed because the Supreme Court's docket was getting overburdened with appeals. The nation was growing. We were coming out of the tail end of the Industrial Revolution. There were so many cases that were being appealed to the Supreme Court that the Supreme Court couldn't keep up. So Congress created this discretionary docket saying, okay, we want you to hear some cases, the more important cases, but everything else, you, Supreme Court justices, have the right to deny. And that was the process that dominated for a really long time, all the way up until 1988, when in 1988, Congress essentially dismantled the entire process of mandatory appeals, giving the Supreme Court free rein to select the cases that it wants to hear. As a result, in the modern era, the Supreme Court has almost complete discretion to set its own agenda. That means it's picking the cases that it wants to hear. Thus, most cases come from discretionary petitions through writs of certiorari, often called cert petitions. So when I talk about a writ of certiorari or a cert petition, I'm talking about the same thing. The process kicks off when a litigant files a cert petition, which again quite simply means that the party is asking the Supreme Court to review a case. There are thousands of cert petitions filed at the Supreme Court each year, but the court elects to hear fewer than 100 cases each term. It's not uncommon for the court to select to hear between 70 and 90 cases in a given term out of the 9,000 or 10,000 cert petitions that are filed. So we have a less than 1% acceptance rate of the cert petitions that are filed at the Supreme Court. This graph provides a visual depiction of the court's docket composition for the last 60 years or so. The pattern should be abundantly clear. Cases from within the court's original jurisdiction, this green line here, comprise a very, very small minority of the cases that the justices hear each term, while the vast majority stem from this discretionary cert petitions. So this blue line, that's always made up the majority of the cases that land on the Supreme Court's agenda in the latter half of the 20th century. But you should note this really dramatic shift that happens right after the Supreme Court Case Selections Act in 1988, which essentially dismantled mandatory appeals, right? So for a chunk of the 20th century, Congress telling the Supreme Court that there were a class of cases that they wanted the Supreme Court to hear. That class would change depending on the priorities of Congress, but Congress had the ability to add cases, types of cases to that, saying if there's a case that it's a bankruptcy case or a tax case or a civil rights case, right? They could pick the type of the flavor of cases that they wanted the Supreme Court to hear, and if there was a case appealed within that class of cases, the Supreme Court had to hear it. The Supreme Court Case Selections Act of 1988 dismantled that process, basically giving the Supreme Court full discretion to choose which cases to add to its agenda. They don't have to do that, right? So the Supreme Court Case Selections Act gave the Supreme Court a lot of authority, but the Constitution says that Congress has a constitutional right to mandate that the court hear certain types of cases. And so there are some differences over time where Congress will send a signal to the Supreme Court that there's a type of case that they want the court to hear. But by and large, since 1988, that process of mandatory appeals has gone by the wayside. We'll talk a lot today about the power that the Supreme Court has in setting its own agenda. And to be sure, its discretionary docket gives the justices a lot of control. But it's important to note from the outset that the court is a passive political institution and must wait for a case to come to it. Judges, no matter where they sit in the judicial hierarchy, can't introduce legislation. And so to enter into the public sphere and help shape national policy, the court must wait until a law is challenged. The Supreme Court's not entirely powerless. It can do things to encourage litigants to submit cases presenting a particular question. For example, the court's published opinions can signal when the justices are interested in an issue or a type of case, which is what the court did at the start of the civil rights revolution in the 1950s and 60s. They sent a signal that they were open to those types of cases. They moved into gender discrimination cases in the early 1970s, sending that same signal like, hey, we're interested in these cases. You can appeal more of these cases. We're going to take them. And so we saw the court is able to send those signals and shape its discretion that way. But they can't just issue a call, right? So even if the court was interested in wading into gender discrimination cases in the 1960s, they couldn't do so until cases were actually appealed to it. They can't just send out a call for cases, for example. The court also faces some constitutional and normative constraints on what types of cases it can accept. Constitutionally, there must be a case or controversy in which the Supreme Court has jurisdiction. So that sounds pretty simple, right? It means that someone needs to file an appeal in a case that the Supreme Court has the right to hear. But this is actually a bit muddier than the Constitution might lead us to believe. As a result, the court adheres to its own internal Rule 10 and demands that a case must be justiciable. Since these are the legal hurdles for an appeal to come before the Supreme Court, we'll go through each of the factors that makes a case justiciable in turn. So let's start with Rule 10. So the Supreme Court has its own rule book for its procedures, and Rule 10 is the only guidance provided by the Supreme Court about what types of cases it will hear. It specifies that cases will only be granted for compelling reasons, where the most compelling is legal conflict, which means that two or more lower courts reach divergent answers to the same legal question. So that means, again, that different lower courts, whether they are state Supreme Courts that are answering a federal question or lower federal courts of appeals that are facing the same question, they're just arising. They're not the same case heard in separate lower courts, but they're the case of the same type, answering the same legal question, reaching divergent answers. So if you think back to a few years ago when the Supreme Court in 2015 ruled that gay marriage was a constitutional right, that arose because there was legal conflict where the Ninth Circuit Court of Appeals and other circuits said that states could not have constitutional amendments restricting marriage between a man and a woman. The Sixth Circuit Court answered that same question in a different way, saying that states did have the ability to have constitutional amendments restricting restricting marriage to being between a man and a woman. So that means that we have divergent legal answers in different federal circuits, right? So that's an example of a legal conflict. There are different types of legal conflict that the court cares about. So there could be divisions within the Federal Circuit Court of Appeals, the example that I just gave you. So that means that there's a circuit split. Right? So again, in Obergefell versus Hodges, the gay marriage decision, the Sixth Circuit Court upheld state constitutional amendments banning gay marriage, while the Fourth, Seventh, Ninth, and 10th Circuits had all struck down similar bans. So this is the type of conflict that is perhaps the most common, but there can also be splits between federal and state laws and decisions of courts within individual states. Rule 10 also says that the Supreme Court will be more likely to hear unsettled, important questions of federal law, but notes that for a petition to be granted a writ of certiorari, there has to be more than just error correction. So a writ of certiorari, a cert petition, is rarely granted when the asserted error consists of erroneous factual findings or a misapplication of a properly stated rule of law. So this means no error correction. Basically, the facts of the case are assumed to be settled before a case reaches the Supreme Court's marble palace. I mentioned that most instances of legal conflict originate within the federal circuit system. So I want to take time to walk through this a bit more to make sure we all understand why this is a big deal. Recall that the Federal Circuit Court of Appeals are organized geographically by circuit. Cases decided in one circuit are binding precedent in all of the states in that circuit, but they're not binding on any other state in the union. So if the same legal question comes up in a second circuit, the judges in that second circuit are free to disagree with the ruling from the first circuit. So when this happens, you get legal conflict, which is bad, because it makes the law inconsistent across the country, and only the Supreme Court can resolve this conflict. This is the same problem that occurs if the states are in conflict with one another, or if a state has a law that is contrary to federal guidelines. To give you a clearer sense of what I'm talking about, this is a handy map that we've already looked at a little bit earlier this semester, but it shows the division of the country into 13 circuits. You should notice right away again that there are only 11 circuits listed here because the two somewhat special circuits are located in Washington, D.C., so both the D.C. Circuit and the Federal Circuit are considered semi-specialized courts because the substantial part of their dockets consist of administrative and patent law cases, respectively. But you should see that if, for example, the Second Circuit is out of step with the Fifth Circuit, then a person living in New York or Vermont would be subject to a different set of laws than a person living in Texas or Louisiana. And this is trickier in the modern era since we travel and we move, and our constitutionally protected rights might be interpreted differently depending where we are in different parts of the country. Okay, so that's Rule 10, which tells us that there's a higher probability that a cert petition will be accepted if there's legal conflict or if there's an unsettled federal question. But the Supreme Court has also established legal hurdles that cases are supposed to clear in order for a case to be heard. That is, a case must be justiciable. There are 5 components that comprise justiciability. The first says that the case must be ripe. This restriction aims to prevent premature adjudication. Basically, this means that the court will not usually address a potential harm, which means that something has to have actually happened to cause harm first. This restriction is most commonly applied to challenges to federal regulations. In short, the person or party bringing the case has to show that there's some sort of redressable issue at stake, which really gets to the heart of the constitutional requirement that there's a live case or controversy. So just because you don't like tax policy, you can't just file suit against the federal government alleging that there's some harm that's occurred. Like, the harm actually has to take place You have to show that this is happening. You can't bring a suit against this hypothetical legislation. It has to be enacted, and then something has to happen. The flip side is that a case must also not arrive at the Supreme Court too late, rendering it moot. So if events subsequent to the filing of a lawsuit in effect resolve the dispute, the case is supposed to be dismissed as moot at the trial level or on appeal or even in the Supreme Court itself. Various subsequent events might make a case moot. If the parties settle over the matter, if the controversy is no longer alive, if the challenge statute or regulation expires or is repealed, then the controversy is over. And any change in circumstance that has the practical effect of ending the dispute is grounds for declaring the lawsuit as moot. So again, this simply means that there actually has to be a case that exists by the time that the Supreme Court reaches the case, so that there's still this live case in controversy, right? Something has happened. The parties in the case are both still active and involved. As a really dramatic example, let's take a quick look at a case called Dupuis versus Overgaard from 1974. This case presented the important issue about whether affirmative action policies in state university admissions programs violated the 14th Amendment. By the time the case was fully briefed and orally argued in the Supreme Court, however, the plaintiff bringing the challenge was enrolled in his last quarter of law school, and the university presented to the court that he would not be prevented from completing his degree program. So the Supreme Court dismissed the case as moot, and it did not reach the merits on the important issue in 1974. So that issue roiled in lower courts for 3 decades before the Supreme Court finally decided Fisher versus University of Texas just a couple of years ago in 2016, even though the same issue was in effect, that Abigail Fisher had graduated from a different university instead of the University of Texas. So technically it was a moot case, but the Supreme Court recognized that it was never going to actually issue a decision in that case if they held hard and fast to this mootness rule. That brings up the fact that the Supreme Court is also the judge of when a case is ripe or when a case is moot, and sometimes they overrule these justiciability guidelines. Like in Roe versus Wade, for example, that certainly happened long after Roe was no longer pregnant, but the court recognized it wouldn't be able to weigh in on abortion cases in the span of 9 months because the appeals process takes a really long time. It typically takes about 5 years for a case from when it starts to make it to the Supreme Court. So a lot can happen in that intervening period. But it is a rule, right? So it's one way that the court can dispose of cases or not take cases, saying we can't weigh in on this case because the case is moot. So sometimes they use this to their strategic advantage, and sometimes they actually use it as a constraint on when and when not they can hear a case. Another key component to justiciability is the idea of standing, which demands that the right person should bring the lawsuit so the courts may provide an appropriate judicial remedy. So to establish standing, first, the person must have sustained some injury in fact, not merely a fanciful, abstract, generalized, or hypothetical worry or concern that everyone has in common. Second, the injury must be fairly traceable to what the other party to the lawsuit did or did not do. So that is that the other party has to have caused the injury. The third component of standing is that the injury must be something that a court can remedy. So that is, the injury must be justiciably redressable. The underlying constitutional principle is that the federal courts must be reserved for resolving real, live disputes that matter to someone, and the judicial branch should not invade the policymaking province of the other elected democratic branches of government. In the garden variety civil lawsuit, the plaintiff sues the defendant who crashed into a plaintiff's car and asks for money for damages. Injury, causation, redressability are obvious. There's no guesswork about who should bring a suit. In so-called public law cases that allege constitutional injuries arising from governmental policies and programs, standing can be rather high hurdle to actually clear. A good example comes from a case called Outgrove versus Newdow, where the plaintiff, Michael Newdow, was an atheist, and he was really upset that his daughter had to say the Pledge of Allegiance at school. And so he brought a suit to challenge the constitutionality of the use of "under God" in the Pledge of Allegiance. But the Supreme Court, which tends to be out of step with public opinion on the issue, concluded that because Mr. Newdow didn't have legal custody of his daughter, his ex-wife did, the sole custody, the legal custody of the daughter was given to the mother, Mr. Newdow was insufficiently connected to the case. He didn't have legal standing to appeal the case, so the case was dismissed. That was helpful to the Supreme Court because the Supreme Court didn't want to weigh in on that question. The Supreme Court consistently has said that prayer in public places is not okay, even moments of silence are not okay. The vast majority of Americans still want to have prayer in public school, and so this is, for the Supreme Court, a really thorny issue where they'd just rather not issue a decision. By dismissing Newdow's case because he didn't have standing, the court didn't have to answer the constitutional question. So that happened quite a long time ago now, and the Supreme Court certainly has had other cert petitions brought to it asking the same question, and the court has simply elected not to hear those cases. There's the power of the discretionary docket at play. Okay, the final bit of the the justiciability question is the political question doctrine, which is essentially a principle of constitutional interpretation and a feature of judicial self-restraint that deems some matters wholly committed to Congress or to the executive branch, and therefore off limits to the judicial branch because of the separation of powers. This doctrine does not place all issues or all cases that are somehow related to politics off limits to the courts. It's not the political issue doctrine. It's more confusing because it's this idea of political question. So for a really long time, things that the court said were not justiciable because they were political questions were questions of apportionment. Again, the Supreme Court reversed its own tactics on the political question of how to allocate seats in the House of Representatives and in the state legislatures in the early 1960s. But for a long time, the court said, that's a political question. That's for the other branches of government to figure out. This is definitely a more confusing and less often invoked aspect of justiciability. But to give you a couple more famous examples, in Goldwater versus Carter, the court concluded that presidential authority to terminate treaties is a political question, that the Supreme Court isn't going to weigh in on the wisdom of a president terminating a treaty, that belongs wholly to the executive branch. In Nixon versus the United States, the courts kicked the case back to the elected branches to determine whether or not the Senate had properly tried an impeachment. Oh, sorry, I just misspoke a moment ago. That was the fourth of the justiciability components. There's one more. The final justiciability requirement is actually a constitutional requirement. And that says that because there's this constitutional requirement for a case or controversy, the Supreme Court is prevented from issuing what we would call an advisory opinion. That is, that the Supreme Court would merely act like a lawyer giving legal advice to a client. Rather, justices may only act formally like a court to resolve real disputes presented by adverse parties. The primary concern here is to limit federal courts to their proper role in the traditional dispute resolution and to, again, avoid these premature, abstract, or political decisions. So, in short, there must be a case with facts and litigants and someone who has been harmed. That is, the court will not tell Congress whether a law it's thinking about is going to pass constitutional muster. Some other countries' constitutional courts do this, where they serve in this advisory role, where the legislative branch can go to the court and say, hey, we're thinking about this piece of legislation. Would this be constitutional? And the court weighs in and says, yes or no. In the United States, that doesn't happen. But other countries like Canada and India do have this advisory role for their courts. Okay, so that's a lot, right, of where the cases come from, what hurdles they have to clear to get to the case. But now we're going to shift gears a little bit and walk through the court's agenda setting process as it relates to cert petitions. So the first step is that someone loses in a lower court. They then have to decide whether or not to exercise their right to appeal. They have 90 days to decide whether to ask the Supreme Court to review a case via the writ of certiorari. This lower court is usually, about 75% of the time, a federal court of appeals. The rest come from state courts. If a party decides to file an appeal, then the petition is received at the Supreme Court by the clerk of the Supreme Court. So if you remember from a couple of lectures ago, we talked about the distinction between Supreme Court law clerks and the clerk of the court. So it's the clerk of the court whose job it is to ensure that petitions conform to all of the various rules. Like you paid the $300 docket fee, you submitted 40 copies of the writ. There's actually a fairly important distinction between regular paid petitions and informal pauperis petitions, where those informal pauperis petitions that the court is making sure, like, whether these petitions play by the rules, there are different standards for regular paid petitions and informal pauperis petitions that are filed by poor people. So informal pauperis, more commonly known as IFP petitions, have a special process. So they're pauper petitions. They're waived of submitting multiple copies, waived from submitting the $300 docket fee, and the like. Many of those IFP petitions often just consist of a letter written by a prisoner with access to law books. So sometimes they are submitted handwritten, right, in crayon. So they have different standards, but it's the clerk of the court who sorts between all of those. But once a petition is submitted, a notice is served to the respondent. So that is the person who won in the lower court. That respondent has the option to respond, to waive the right of the response, or to do nothing at all. The petition and any response are then distributed to justices' chambers for review. And who do you think reviews those petitions? Well, it varies somewhat across chambers. Generally, law clerks take on the burden of reviewing the cases and providing a summary of the case, including a recommendation about whether or not the court ought to grant or deny that cert petition. Remember that there are upwards of 9,000 petitions filed each term, so it's a massive workload to review all of those petitions. Since 1971, many justices use the cert pool to reduce burdens on their law clerks. This is an interesting process that we're going to spend several minutes dissecting in a little bit of detail. Okay, so before we get there, let's back up and take a look at this graph. So this graph is hopefully succinctly showing that there are an incredible number of petitions filed each term. In the current era, there are more than or around 9,000 petitions filed each term. So again, big workload to review all those petitions. You should take note of the types of petitions filed. The dotted line here represents the paid cert petitions, while the thin black line represents the petitions filed by poor or indigent petitioners every year. The thick black line is adding those two things together so that you get a grand total number of the cases filed at the court each year. So you should notice that there was a rather gradual increase in the number of cases filed from the 1930s to the 1960s, right? So this is pretty modest. Slight increase, but nothing really to write home about. And then something changed. Suddenly there was this really big jump in the 1960s. We went from having just under 3,000 cases filed to way more than 4,000 cases filed in a given year. So think for a second, why might this be? If your first guess is to connect this to the civil rights movement, you'd be correct. The court began to wade into civil rights and liberties cases, especially heavily in the 1960s, and as a result, there were thousands of new types of petitions that came pouring in. It was in response to this that the court knew it needed to do something to manage its burgeoning caseload, and the cert pool was created as a result. One more note before we talk about law clerks and the cert pool, however. check out the leveling off of paid petitions from the 1970s onward, right? So we're looking again at this dotted line. It rose in the 1960s, but then it has really leveled off in the subsequent decades. On the other hand, we have seen this continued upward trend if we're looking at this thick black line, right? So that upward trend is driven primarily by the steep increase in the number of IFP petitions submitted every year, especially from the 1980s onwards. Any guesses why that might be? Think about this country's war on drugs in the 1970s and 80s and the explosion in the prison population in the last few decades. As more people are in prison, more IFP petitions are filed. So this pattern tracks really closely with the war on drugs and war on crime. As we quadrupled the rate of people in prison in the 1980s and 1990s, so too did we see this explosion of IFPs filed at the Supreme Court. Okay, to alleviate the burden of sifting through thousands of cert petitions every year, the justices rely heavily on their law clerks to provide the initial review. The question for justices then is how to expedite the process in such a way that utilizes law clerks in the most efficient way possible. Remember that sorting petitions is not the justices or the clerks' only jobs. They also have to hear oral arguments, they have to actually decide those cases, they have to write opinions in those cases, all of which are really time-consuming tasks. So when the number of petitions started to climb dramatically in the late 1960s and the justices and their clerks were struggling to keep up with the burgeoning caseload, the Supreme Court implemented an experiment by combining their law clerks from across the justices' chambers as a way to divide labor among the clerks, so that not each individual justice's clerks were all reviewing the petitions, but that they could divide and conquer. So the purpose is to provide a standardized brief about the petition that all of the chambers could then use to aid in their decision-making process. So in other words, the cert petitions are distributed evenly among the law clerks so that each chamber isn't responsible for reviewing all the petitions, effectively reducing redundancy of labor among the justices' clerks. While this is a very popular idea, it was met with a bit of resistance and continues to be a source of controversy because when the justices pool their clerks into a common shared group, they obviously lose some of their own autonomy. Justices are really particular about who they take on as a law clerk, and they might be more trusting of petition reviews by their own clerks than of reviews done by other justices' clerks. So for example, when a conservative justice like, say, Thomas participates in the cert pool, he reads cert memos or the summary of the cert petition by clerks from liberal justices like Justice Breyer. The same is true for liberal justices. There's also a concern that when clerks write for the entire court, rather than just the justice for whom they work, that they lose the ability to be open and honest, as they otherwise might be if they were working just for one primary principle. And perhaps more importantly, by assigning a case to a single law clerk, that puts a lot of responsibility and power in the hands of that clerk to make the right recommendation for the court. Once a law clerk reviews the petition, he or she writes a cert memo, and the cert memo gets distributed to all of the justices who participate. The justices will usually engage in some form of post-pool markup, where they can agree with the recommendation, they can agree with reservations, or they can wholly disagree. But the goal of the review by the justices is to provide a check on the pool clerk and any attempts that he or she, the clerk, might make to manipulate the process. With these checks in place, most of the justices participate in the cert pool, and it seems to be a fairly efficient system. In recent years, only former Justice Stevens and current Justice Alito participate in the cert pool. Alito opted not to participate in the pool after joining initially. So there is some flexibility. Just because you're in the pool doesn't mean you have to stay in the pool. You can pull your clerks out and have your clerks review all of the cases independently if you so choose. Since cert pools play such an important role in the agenda setting process, I think it's fun to actually take a look at a couple of them. These memos are not released to the public and come from the private papers of Justice Blackmun, housed in the Library of Congress. Here's the top of a memo from a case in 1992 concerning bargaining power over private airlines and public airports proprietors. So in this particular case, it's Northwest Airlines and Kent County International Airport, which is now known as the Gerald R. Ford International Airport in Grand Rapids, Michigan, obviously. You'll see that clerks routinely provide commentary on the case, even in the presentation of the parties. So, for example, in this case, summarizing Northwest Airlines' position, the clerk writes, "Outrageous airport charges make our red eyes blue." So it's sort of cheeky and it's clever, and they're entertaining and humorous to read oftentimes, rather than just being these dry summaries. So you see the clerk's personalities reflected in the presentation of these cert pool memos. But beyond this sort of cheeky cover page, cert pool memos follow a very standardized format. They all have a cover page with the name of the case and its docket number, followed by a short overview of the case, a review of case facts and the procedural history, so the lower court decisions. They provide a summary of arguments made by the petitioner, and if present, the respondent. So remember, a respondent doesn't have to respond. They're served with the fact that a cert petition has been filed at the Supreme Court, and then they have a choice to respond or not. So if it's there and they've provided an argument against the petitioner in the case, the law clerk will also summarize that argument. And then the clerk weighs in and offers an assessment of the strengths of claims made by both the petitioner and the respondent if they're present. And then ultimately the clerk concludes with their recommendation of whether or not the court ought to grant a writ of certiorari in a particular case. Well, it might seem possible to gain a lot of insight from clerks' pool memos alone. Clerks invest a lot of time to thoroughly summarize and analyze the case to bolster their recommendation about whether to grant or deny review. There's a lot of pressure on clerks to get it right, because if they recommend a case that isn't ripe for the court to hear, for example, the justices can still dig it, which means that they dismiss the case as improvidently granted. That would be a major blow to the clerk, since it means that the court is saying that they made a mistake in taking a case. So they're dismissing the case after they've granted it, saying, "Hey, we made a mistake. We have no right to hear this case. We don't. We need to kick this case." And they took that case on recommendation from a clerk. So there are reputational issues at stake here. There's also a pretty significant variation in the length of these memos. Pool memos are typically about 7 to 12 pages long, with the modal category being in about the 7 to 8 page range. So if you think about all of the things that are contained in a cert pool memo, that's actually a pretty short amount of time or page length for the clerks to do all of the things they have to do, for justices to review those memos to issue a decision. The graph that you see on this slide depicts the division of attention in those briefs. So cert pool memos are divided so that the briefs focus attention very largely on case history, outlining the legal claims made by both the appellant and the respondent, and then the clerks conclude the memos with their own briefer discussion of the case and their recommendation for how the court should treat the position. So the clerk's own views are about 18% of the pages dedicated to writing this pool memo, where about 80% of the brief focuses on what's happened in the past and what arguments the parties are presenting in the case. After a clerk finishes the cert pool memo, the memo goes to all of the justices in their pool. And then most justices have their clerks look at that pool memo just to make sure that they agree with it, that nothing seems to be amiss. That's called the markup process. Occasionally, that markup process actually leads to disagreement, right? Where a clerk recommends something and a justice ultimately disagrees with the recommendation that the clerk made. When we're looking at Justice Blackmun's papers, his in-house clerks, his own chamber clerks, catch things that lead Blackmun to disagree with the cert pool recommendation about 18% of the time. So it's not totally uncommon, but the most common area of disagreement is whether or not there's actually legal conflict that exists. So whether whether this is a worthy case for the court to hear, whether it's clearing this Supreme Court Rule 10 regulation. The clerks for the court provide, the clerks for each individual justice write like their little markup report. If there's no disagreement, they sign off on it, usually in like a very, very succinct little piece of paper with about 7 lines. If there's disagreement, it's about 15 lines, right? So this process of marking up a cert pool memo is really short. It doesn't take a whole lot of time, but it's a notable part of the process. Okay, so let's set that aside. Once the clerks sift through the petitions, the first major hurdle to getting a review is making the so-called discuss list. So this is a list of all of the petitions that the justices will discuss and formally vote on during their weekly conference meetings. So we have these 9,000-ish petitions that have been submitted to the court. The clerks go through all of that entire list of 9,000 cases. They make recommendations about whether to grant or deny. The justices discuss these cases in the markup process with their own in-chamber clerks, and then the justices go to sit with the other justices during these weekly conference meetings where they have the choice of what cases they're going to discuss, right? They're not going to together weigh through 9,000 of them. So they create this discuss list, this list of cases that they actually think are worth a second look of talking about together as a conference. The Chief Justice gets the first crack at generating a discuss list, creating an actual list of what he deems are cases worth considering. By initially whittling down the petitions from the thousands to the hundreds, the Chief Justice exerts substantial influence on the potential shape of the court's agenda. So the Chief Justice does it first, right? He generates this list of several hundred cases that he thinks are worth the second look, and then he circulates his list, and any of the remaining justices, the associate justices, can add a petition that they think the chief missed that they'd like to talk about, and no one can remove a case from the list. So the list can grow, but it can't shrink after the Chief Justice creates the discuss list to begin with. While the justices have a lot of discretion at this stage in the game, they've all agreed that all death penalty cases are worth discussing. So those are automatically added to the list. Prior to the implementation of the discuss list in the 1970s, there was something called the dead list, which is precisely the opposite. The justices created a list of cases that were not going to be discussed or voted on. In short, if a case didn't clear that first hurdle and didn't make it onto the discuss list, then the court doesn't have a formal vote, and those cases are automatically denied. So once again, discuss lists are not things that are released to the public. So anything we learn about the treatment of discuss lists, what previously had been dead lists, right, comes from the justices' private papers that are released after those justices leave the court. The most recent discuss lists are available in the papers of Justice Blackmun. So over 8 terms from 1986 to 1993, the court discussed approximately 800 petitions per term. Some of those petitions were IFP, those informal pauperous petitions, and they were discussed simply for being in violation of IFP status. But of the non-IFP petitions, roughly a quarter of them are granted review. So they hear about 10%, little under 10% of the cases, or they discuss about 10% of the cases that are appealed to it, ultimately elect to hear about 10% of that, where a majority of the cases that the Supreme Court actually hears come from those paid petitions. It's rare for IFP petitions to actually make it onto the Supreme Court's docket. Right? So just by way of really, really quick review, because I know there's a lot going on here, the Chief Justice creates a discuss list of cases that he thinks are worth talking about in conference. All of the other justices can add to that list, but they can't take away from it. It's from that list, from that discuss list, that the justices work from to ultimately decide which cases will be granted review. Any case that doesn't even clear that first hurdle of making it on the discuss list is summarily denied, right? They aren't going to talk about it. It's simply just denied review. Before the implementation of the discuss list in the early 1970s, the court used the dead list, where they just listed the cases they didn't want to talk about and they talked about everything else. So it's this inverse process happening here. Okay, so now we're going to assume that we've got the discuss list created, and we're going to talk about the process that the court actually selects the cases for review. So every Friday that the Supreme Court is in session, it holds conference to select cases for review. Voting in conference is sequential. The justice who placed the case on the discuss list can offer a justification for why a petition should be granted review. The justices then vote in descending order of seniority, with the Chief Justice considered most senior. So in the current court, Chief Justice John Roberts kicks off voting on the cert petition. Justice Kennedy follows on down to the most recent justice. Justice Gorsuch, in this case, votes last. Most of the time, in fact, 85% of the votes cast at this stage are these straight up votes to grant or deny a petition. If a cert petition does warrant review, Supreme Court rules mandate that 4 votes are required to officially accept or grant the case. If the petition doesn't get 4 votes to grant, it's denied. However, a denial does not necessarily mean that the Supreme Court is in agreement with the lower court's decision, but it might not want to take the case because it's waiting for a better one in a given issue area, or because it isn't enough of legal importance to land on the court's agenda. But to stress here, you need to have a minimum of 4 votes to grant review. This is not a majority. It's a sizable minority, right? So 5 justices might not want to hear a case, but if 4 justices do, they're going to hear that case. If the Supreme Court doesn't hear a case, right? So most of the cases that are appealed to the Supreme Court, the court doesn't ultimately hear. Then the lower court's decision stands as controlling precedent from the circuit or the state in which it arose. That's not the Supreme Court giving its stamp of approval to it, but it allows that legal rule to exist in the meantime. Beyond granting or denying, the court can also grant, vacate, and remand, or GVR a petition because of a recent decision. In layman's terms, this means that the court sends the case back to the lower court for review because the Supreme Court recently issued a decision in a different case that has implications for the one at hand. Additionally, in an extreme case, the justices could decide to summarily reverse the decision of the lower court, which means they overturn the lower court's decision without a full hearing in the case. While these agenda-setting votes are not public, a justice can dissent from the denial of certiorari in a petition. That is, a justice felt so strongly that a case should have been granted that he or she is willing to take her beliefs public. Justice Byron White, a former football player, had a habit of doing this, but otherwise it's a relatively rare practice. A justice might issue a threat to dissent from denial as a strong-arm tactic, so an ultimatum for the rest of the court by showing disunion among the members of the court, so the court might try to avoid that, because they don't typically like these dissents from denial, because it just shows that there are politics at play, that the justices aren't in unanimous agreement. There are dissents from denial of certiorari that can happen, they just don't happen all that frequently. There are also non-terminal outcomes that can happen at the agenda-setting vote as well. So the justices might vote to hold over a case, and that means that the court will wait to make a final decision about whether or not to review the petition because there's a pending case before the Supreme Court that could be related. If this respondent had waived their response, the court can CFR, which is call for a response, and elect not to make a cert decision until they review the arguments from the respondent. And finally, the Supreme Court can call for the views of the Solicitor General, CVSG, which means, again, to quite literally call for the views of the Solicitor General. This occurs when the justices want the Solicitor General to weigh in on the case, and that's something that we'll talk about in greater detail in a subsequent lecture. There's one more special type of vote used in agenda setting that is worth discussing. During a conference, a justice can also cast what is known as a join three vote. This is a conditional vote to grant. If 3 or more justices vote to grant review, then the J3 vote, the join 3, the J3 vote, becomes a grant vote. Otherwise, it's a vote to deny. So, for example, if there are 3 grants, 5 denies, and 1 join 3, then review is granted. If there are 2 grants, 6 denies, 1 join 3, that join 3 switches to a deny, right? So the join 3 is strictly if there are 3 grant votes. Join 3 votes are not stackable. So, for example, if there are 2 grants, 2 join 3, and 5 denies, the review is denied because those 2 join 3s don't have enough straight up grants to join, and so those join 3s function as denies. About 3% of all votes cast were join 3s. There's at least 1 J3 vote in 21% of all petitions. This is sort of used as an in-between vote to signal collegiality or uncertainty about the merits of a particular case. Let's turn now to look at an example straight from the private papers of Justice Blackmun. There are a lot of moving parts at this stage in the game. Obviously, right? You've been exposed to this over the last hour or so. So to keep track of everything that happens in a case, each justice has a docket sheet for every case. In other words, each cert petition receives a docket sheet, and it is on this piece of paper that the justices keep record of the history of the case. In addition to the name of the case, the top of the docket sheet contains the court of origin specifying where the appeal came from. If the case is granted review, it also contains the date of oral argument, if applicable, the date of the opinion announcement, and the date the decision of the court is announced. The upper right-hand corner includes the docket number that is assigned to that case. The bottom of the docket sheet contains the entire voting record for the entire history of the case for every justice. So you can see that Justice Blackmun recorded the cert votes for all members of the court during the agenda setting stage, and the final votes for the merits after oral argument. You should note the options for the discuss list vote. You see that there are the defer options in the leftmost column, and the cert, grant or deny, the G and D options, along with the grant, vacate, and remand, the GVR, in the highlighted column. This is a snapshot that illustrates a join 3 vote from another case. You'll notice that during the agenda setting vote, Justices Brennan, Powell, and O'Connor all vote to grant cert, right? So there are 3 justices voting to grant cert, while Justices Rehnquist, Marshall, Stevens, and Scalia all voted to not deny. Justice White cast a vote to join 3. That's what this little 3 indicates. In this case, because 3 justices voted to grant, his vote becomes the 4th vote necessary to add the case to the Supreme Court's agenda. If only 2 justices had voted to grant, his vote would have switched to deny. That finally brings us to the conclusion of a rather technical procedural lecture to get to the legal aspects of the agenda setting stage of the judicial game. You've been introduced to a number of key terms, so you should spend some time making sure you understand this jargon so that you can both identify it and use it in written work. Make sure that you understand the appeals process, the function of the cert pool, and so forth. Next time we'll pick up with the social scientific research on the choices that justices make during the agenda setting process. As always, thank you for your attention.